And finally, number 10, I'm not sure if I talked about this before, but it's country of chargeability for diversity visa cases. We have a case where a person, or a consult, where a person's parents were visiting another country when they were born, like 40 years ago, and had the baby where they visited, and they returned to the home country. So their place of birth was that country. And that creates diversity visa issue problems because I forgot what the law is, but essentially you have to show that the parents were like there temporarily and not for business or work or more permanent or vice versa. And that messes up the country of chargeability for diversity visa. In this case, they're probably going to get denied for it because they listed their home country as opposed to the country of birth, and they should have listed the country of birth, at least according to what the embassy says. And they want documentation to show the parents were only there temporarily. This is like 40, 50 years ago. They don't have documentation of this. So how are you going to prove that there was a temporary visit? They don't have the old passports or travel history, all that kind of stuff. This is pre-email, internet kind of stuff. So they lucked out to win the lottery, but they ended up losing the lottery at the end of the day, not getting the visa. Or I mean, they have 10 more days unless they figure it out. So it's a very sad situation, very frustrating for those people. But yeah, this chargeability stuff, it gets, nothing's easy. Nothing's easy. And DV lotteries, a lot of times you see these kind of mistakes happen. They forgot to name a child in there, or spouse, or something like that. But this country chargeability is something to study. It's more complicated than you think, and it pops up in other cases too. For EB cases, for example, if you got a backlog Indian case, they marry a spouse in another country. You got to know the country chargeability situation. Speaking of which, I got a case where there was a guy doing adjustment of status, Indian guy, and he couldn't do adjustment because his case was current, but he married like a Swedish person. So he had filed for adjustment of status, and then he contacted me just to prep him for the interview. And I didn't even catch this. Honestly, I didn't know it. It's kind of embarrassing. But I'm like, okay, just go here. I mean, it's no malpractice because he was going to interview anyways. And went to the interview, and they said, oh, for when you're doing country chargeability adjustment of status, the spouse has to be with you and adjust at the same time. So they denied the case. And so we had to do it in like an I-24, I think. I can't remember exactly. Get the case to the embassy, get the wife like approved to come in, or a tourist visa to come in to adjust with him. I honestly, it was like 4 years, I can't remember. But that kind of was, it's in the policy manual too, USA's policy manual. At least at the time was when I read it. If you're going to use country of chargeability of a spouse, they got to do it with you at the same time, or some situation like, oh yeah, so he was on H-1B. So the spouse got an H-4 and then came here on the H-4. They adjusted status together because now they were going to do it together. That was permitted. So that was the nuance of country chargeability.